Joshua, thank you very much indeed for that astounding welcome. Thank you very much indeed. It's not really the day to be wearing this kind of kit, I can tell you, with fur. Well, it's fake fur. I also discovered that this sort of kit's not very good with a folding bicycle. I don't know how I'm going to explain the bicycle oil on the gown to Ian Ravenscroft when I send the gown back. Thank you to Joshua and thank you to colleagues at Middlesex for setting this up to Yvette and Haley who are standing at the back. It seems to me that we have a fight on our hands. The European Court of Human Rights is under sustained criticism, much of it ill-informed. What is more, the long-term standoff over prisoner voting rights has led to the UK being in breach of the Human Rights Convention, having failed to implement judgments going back to 2005. It's also deplorable that leading politicians here have made statements, the effect of which is explicitly to negate the rule of law. The Prime Minister told the House of Commons in October that prisoners would not get the vote under his government. And a draft bill has now been published with 3 options, but one so-called option is no change to the current blanket ban on prisoners voting. For some, the European Court has strayed into the realm of judicial lawmaking, apparently usurping the powers of our elected representatives. In March, the Justice Secretary Chris Grayling was reported as demanding a dramatically curtailed role for the court. And only last week, the court issued its judgment in a case brought by Animal Defenders International, an NGO which wanted to run an advert on television highlighting the keeping and exhibiting of primates in zoos and circuses and their use in TV adverts. But they fell foul of the general ban on political advertising in this country. Chris Grayling questioned whether the issue of political advertising was even within the court's remit. Of course it's within its remit, and that then allows the court to adjudicate on what are sometimes difficult and finely balanced issues. And in its judgment, the court went on to find that the ban on political advertising did not, in fact, breach the right to freedom of expression by just 9 votes to 8, having given considerable weight to the depth of the consideration to the political broadcasting regime that the domestic courts here had already made, and also that Parliament had made. The court is also under attack because of its huge case backlog. I've got some pictures as well as some words you'll be glad to hear. Currently 122,000, you can see Russia there leading the way, although these are pending cases. Russia there with just under 26,000. And for some academics and commentators, this shows that the court, in its current form at least, has had its day, and that it should accept its true métier as a constitutional court for Europe, one which pronounces on broad standards for 47 European states, but doesn't bother itself with the grubby issue of individual justice. Although it's far from a perfect institution, I want to defend the European Court, not least because of the extent to which it offers a measure of justice and accountability for the victims of human rights abuses. I also want to examine how it does so, and to consider how violations, especially gross human rights violations, can be adequately redressed. This is against a backdrop of what Professor Dinah Shelton has rightly argued is inconsistency and incoherence in the practice of granting redress within the field of human rights law. The Kurdish cases brought against Turkey in the early 1990s first introduced the phenomenon of the enforced disappearance into European human rights jurisprudence. And they also led to a series of findings of violations by the Turkish security forces, constituting torture and extrajudicial executions, and the large-scale destruction of homes. More than 3,000 villages were destroyed in southeast Turkey in that period. A large number of cases were then taken to the European Court of Human Rights, although of course they represented only a small percentage of all the violations that were committed. One remarkable feature of that process was the fact-finding. As the Turkish courts were not hearing such cases, the European Court felt it had no choice but to send a delegation of its judges to Turkey to hear witnesses to try to find out what had happened. I represented some of the applicants in those cases, and it seemed to me to be an indispensable and profound exercise in the provision of justice. It was the first time that those families, many of whom were illiterate farmers from tiny hamlets in southeast Turkey, was the first time that they'd ever been able to tell their stories properly to officialdom, and not just to judges, but to international judges. And in a very high proportion of cases, those families were believed, in contrast to the blustering members of the security forces who turned up to give evidence. So their cases in Strasbourg were successful, and the court ordered Turkey to pay damages, which it duly did in each case. But is that enough? This is one Turkish cartoonist's view in response to that question. 20 years later, and after numerous European court judgments, what's the legacy now for Turkey? This was discussed at a Law Society seminar in February by Professor Françoise Hampson from the University of Essex and by the Kurdish lawyer Tahir Elçi in Human Rights Watch. It's now the case that as more and more unregistered burial sites and mass graves are being uncovered in southeast Turkey and human remains being excavated, there is a greater expectation that prosecutions in Turkey will now follow. And this slide is a map of burial sites published by the Human Rights Association of Turkey. However, with a few exceptions, one being the ongoing trial of a retired colonel from Diyarbakir in relation to murders committed in Şırnak in the mid-90s, the sober reality is that there have been very few attempts to bring perpetrators to justice in Turkey, with statutes of limitation now potentially blocking that from ever happening. The security forces in Russia, operating in Chechnya and other republics in the North Caucasus since 1999, have been responsible for a comparable catalogue of egregious breaches of the Convention since 2005. And for 10 years now, as Joshua mentioned, the European Human Rights Advocacy Centre has been representing applicants from Russia and some of the other former Soviet states before the court, notably in those Chechen cases. And it's at this point that I do want to acknowledge and thank my Iraq colleagues for their extraordinary work, and they're all sitting in the first 2 or 3 rows here this evening, and also to express our sincere gratitude to Joshua and many other colleagues at Middlesex, some of whom are here this evening, for the very warm welcome we have received since moving here to Middlesex in January. Now, our work on these cases has been done in collaboration with the Russian NGO Memorial. And I have to mention that only yesterday we heard that under the very new repressive NGO law introduced at the end of last year in Russia, Memorial has been served notice yesterday by the Moscow prosecutor's office requiring them to register as a foreign agent. And that phrase in Russian has the same connotations as it may do for us. It means that they're spies, they're labelled as spies. And that's on the basis that they are funded from abroad and that they engage in political activity. If they refuse to do so, they face a series of sanctions, including fines, suspension of their activities and criminal prosecutions. And this slide, it's a little bit dark, but this slide is of a mysterious-looking character. That's actually Oleg Orlov, one of the heads of Memorial, outside his office in Moscow. And the Russian literate people amongst you will know that that says "Inostrany agent," foreign agent. And then the people who can't read Russian can see the heart and USA, which was the graffiti written on Memorial's office just after the time when the law was introduced. Now, I want to give you 2 examples of our cases just as illustrations. And the first concerns the actions of the Russian federal forces in Grozny, the Chechen capital, in the year 2000. Mrs. Kayedi Makhauri lived in Grozny with her husband and their 5 children. At the end of 1999, they left, fleeing from the fighting that had consumed the area. And in January 2000, she saw on the television reports that people were returning to the area as Russian federal forces had gained control. And so they went back. She went back with two of her neighbours and friends to check on their houses. When they arrived in Mrs. Mehari's street, these are just library pictures, by the way, they found that her house had been destroyed. The three women were stopped by Russian soldiers who had been looting properties nearby. They were searched, they were blindfolded, and they were led away to the courtyard of another destroyed house where they were shot. The two other women died, but miraculously Mrs. Mehari survived, regaining consciousness at one point when a gold earring was torn from her ear, and again later when she found that a burning mattress had been dumped on top of the three bodies. She was later found and cared for by other locals who were living in the cellars of nearby houses at the time. Now, some 7 years later, Katyn Mehari secured a judgment at the European Court which tells you that story in a bit more detail, and which found the Russian state responsible and in violation of her right to life. Yes, her right to life, even though she survived. In other words, they got no credit for having failed in their attempts to kill her. Now, my second example is, this is Nurjan Abdulkadyrova, whose house in Urus-Matan in Chechnya was raided by masked Russian soldiers in September 2002, where she was living there with her husband and their three children. It started when the door into their courtyard was broken down by a soldier in a balaclava mask with an automatic weapon who shouted, "Everybody out in the street, bitches." Nurjan's husband was taken away and he's never been seen since. The following day, Nurjan began searching for him, going to the district prosecutor, the local military commander, and the Department of the Interior, all of whom denied any knowledge of him. She then travelled across Chechnya when she heard of unidentified bodies being found, and she applied to the district court, all to no avail. Before the European Court, the Russian government accepted that Nurjan's husband had been taken away by armed men, but denied any state involvement. The court, however, found it established that he had been detained by state servicemen during an unacknowledged security operation and that he had died following his unacknowledged detention. Not only that, but the court also concluded that the authorities' conduct in the face of Nurjan's well-substantiated complaints, in other words, that they did little or nothing to investigate, gave rise to a strong presumption of at least acquiescence in that situation. Now, these cases are at the same time remarkable and routine. They're remarkable, I think, as examples of the revolutionary and unique mechanism that the European Court represents, in that it enables individuals, the ordinary woman, the ordinary man, to challenge human rights abuse perpetrated by the state through an international process, the results of which are legally binding. But their circumstances are also sadly relatively commonplace. And it does seem to me that beneath the noise of the political posturing in this country about a supposedly self-aggrandizing court, these are the sorts of cases that we need to hear more about. And as Sigrid Rausing argued on returning recently from a trip to the South Caucasus, democracy and the rule of law on the margins of Europe should matter to us all. But how, to come back to the title, how can justice be achieved in response to an enforced disappearance? Hisham Matar is a Libyan writer with whom I spoke at an Amnesty International conference on disappearances in 2010. Matar's father, a political dissident under the Gaddafi regime, was abducted in Cairo in 1990. He was reportedly transferred to a notorious prison in Tripoli, but he's never been seen since. Both Hisham Matar's novels concern the phenomenon of enforced disappearances, and these passages from his second novel, Anatomy of a Disappearance, convey something of the anguish experienced by the relatives of the disappeared and their need to find out what has happened. Situations like this, entailing gross and systematic human rights violations, arguably justify a significant step up in terms of the remedial response by an international court. The very nature and scale of the violations are likely to require a radical rethink about the suitability of reparation. For example, what constitutes appropriate redress where an applicant's relative has been disappeared, where no body has been found, and where similar cases are common. And these cases aren't, of course, just about individual justice. Much broader questions arise about wider societal healing and the relevance of principles of restorative justice, such as reintegration and rehabilitation. Writing recently about the Spanish Civil War, the historian Paul Preston has been reflecting on the public right to historical memory and what a difficult and painful process it can be to get anywhere close to achieving it. The only other international court which has had to adjudicate on a comparable body of egregious systematic human rights violations is the Inter-American Court of Human Rights, the body which has a similar role to the European Court for South and Central America, which has often had to deal with such situations since it published its first judgments relating to disappearances in the late 1980s. And in the ensuing 20 or so years, it's developed a more expansive jurisprudence on reparations in cases of egregious violations. For example, the Inter-American Court can order the state to make a public apology to victims, acknowledging its responsibility. It has acted innovatively by introducing the concept of damages to the victim's life plan, which reflects their circumstances, but also their future ambitions and their future potential. And in adjudicating on disappearances and extrajudicial executions, the Inter-American Court has upheld the right of relatives and of wider society to be informed about what happened, has ordered the governments to locate the remains of victims and provide them to the next of kin. The Inter-American system has also led the way in responding to collective rights violations. For example, awarding collective damages to be paid to a development fund for the benefit of the group in question, requiring monuments to be erected commemorating victims, the holding of public ceremonies of acknowledgement, and the provision of medical, psychological and psychiatric treatment to victims. As yet, however, the European Court has not generally been willing to follow the example set by the Inter-American Court as regards its more nuanced and holistic approach towards reparations. But I want to turn now to the new ways in which the European Court is providing redress, and also crucially to the ways in which states respond. It's been quite common for the court simply to make a declaration that there has been a human rights violation. In other words, a judgment which explains why there was a breach but goes no further, sometimes not even requiring the payment of damages. And that approach has been criticised. For example, this is what the redoubtable former Maltese judge Giovanni Bonelli had to say in one case. And in case you can't read it, he said, "Hoping to satisfy a victim of injustice with cunning forms of words is like trying to quench the thirst of a parched child with fine mantras." But how do states respond? Well, they do in fact pay the damages ordered by the European Court. Crudely put, the going rate for a life seems to be about 60,000 euros. But such payments seem to be very inadequate. Remember the Turkish cartoon slide. For those of you who couldn't see it, here it is again. And it's not uncommon for there to be very protracted delays in complying with some judgments and considerable political resistance. Witness our Prime Minister's response to prisoners voting. Of course, he famously said that it would physically make him sick. The effective and timely implementation of judgments has been a significant challenge for Europe for several decades now, especially the failure of governments to resolve large-scale systemic human rights violations. So when the judicial system in a country fails to operate reasonably efficiently, as has been the case in Italy, for example, there have been multiple breaches of the right to a fair hearing within a reasonable time, and thousands of those sort of cases clog up the Strasbourg court. Two of the court's more recent responses to this problem relate to redress. The first is that it started to issue a new type of judgment which not only sought to diagnose the systemic problems, but also established a binding legal duty on the government to resolve them, often by introducing new legislation. And this has already been pretty successful in some situations. Take, for example, the Broniowski case. Jerzy Broniowski's family lost their home and farmland when they were repatriated from what now is Ukraine to the east of the Bug River, back into Poland. After the borders of Poland were redrawn in the aftermath of the Second World War. His family were due to be compensated under the Polish domestic law, but the law simply didn't work. And he was at the head of the queue in Strasbourg, and there were 80,000 people believed to be in a similar position. So rather than deal with 80,000 cases, the European Court required Poland to introduce new legislation to solve this problem, which was indeed, in that case, done within a year or so, and families were then awarded compensation in Poland. But take a more recent example from Russia, about the appalling state of Russian remand prisons in particular. And to illustrate this slide, we've got some rather famous, more famous recent inhabitants of Russian prisons. Mikhail Khodorkovsky down here. This is Sergei Magnitsky, the accountant who died in a Russian prison, aged 37, I think he was. And of course, the Pussy rioters up at the top. For 10 years, the European Court has been issuing judgments on this issue against Russia, highlighting the overcrowded cells, the absence of space to sleep, the failure to ensure adequate heating, lighting or fresh air, conditions that are inhuman. And in the Ananyev case last year, the court produced a judgment that was remarkable, I think, in the terms of the depth of its diagnosis of this problem, starting with very practical, relatively simple, cost-free steps, such as removing coverings from cell windows, installing a curtain to shield the toilets in a cell. But the judgment also ranged far beyond that to consider the legal framework and judicial policy, making it clear that the rate of imposition of pretrial detention in Russia is excessive and unjustified, and that alternatives to that are needed. But the legal cutting edge of the judgment required the government to provide redress within a year, not only to Mr. Ananyev, but also to every person who'd lodged a case in Strasbourg against Russia raising that issue before the date of the judgment. There were more than about 250 cases pending, and so judgments like this represent quite a significant move towards a more collective approach to justice at the international level. Now, the second redress-related response of the European Court to the problem of implementation, which I've described, is to be far more incisive in terms of the specific obligations imposed in judgments. As I said earlier, the Court's usual approach has been to issue declaratory judgments, which simply state that the Convention has been breached and explain why, coupled with the award of damages where appropriate. But the Court is no longer restricted in that way. For example, where individuals are clearly being held unlawfully, it will now order their immediate release, as the court did in 2010 for the Azerbaijani journalist Einullah Fatullayev, after he was prosecuted and sentenced to several years' imprisonment for defamation. The most recent example of this more interventionist approach, in fact, came in one of our cases at Iraq. So let me introduce you to former Ukraine Supreme Court Judge Oleksandr Volkov, who was a victim of the endemic political corruption in Ukraine. And in a subversion of the principle of the separation of powers, a small coterie of powerful politicians in Ukraine are able to appoint and dismiss judges almost at will, as happened to Mr. Volkov. The court found that this breached his right to a fair hearing in several different ways. His dismissal was approved by a vote of the plenary Ukrainian parliament, and in his case, 247 MPs apparently voted in favour of his dismissal, which was remarkable given that that number was far higher than the number of MPs who were actually present. And if this works, here's a clip of film which shows you how they voted. Let's see if this works. This is the Ukrainian parliament, and while you're getting your heads around why, in a dismissal case, the whole of the plenary parliament should vote in a case like this anyway. Oh, that's not right. Let's see if it'll come on. It really did work before. It'll probably work later when we're having a cup of tea later. So you're going to speak? No, okay, let's go back. I mean, the picture there shows you what happens is that the MPs, they vote using the voting pads of all the MPs who are not there. And it's a breach of the Ukrainian constitution. There's a clip of film of the vote in the Volkov case, which was submitted to the court, and they were able to see that. And it's an outrageous breach of the constitution in Ukraine, actually. And Jane Gordon's here, who did the case with us, and before the court in Strasbourg, we were able to demonstrate to the court what it's called playing the piano, because they reach across and vote like that. And it's very common. It's a common phenomenon in Ukraine. Now, having done that, I think the thing will probably work now. Anyway, let me move on, because as a result of that decision, the system for appointing and dismissing judges in Ukraine will have to be changed, which will therefore require an amendment to the constitution of Ukraine. But I mention this case not just to tell you about the voting patterns in Ukrainian parliament, but particularly because of the court's take on the requisite redress for Mr. Volkov. Given the political structure and the situation in Ukraine, the court found that there was simply no point in ordering his retrial, and so instead the court, in its judgment in January, ordered his reinstatement as a Supreme Court judge. And that's the first time the court has ever made such an order. We're going to have a clip now, are we? No, let's go on. I'm going to leave it. I'll show it to you later. First time the court's made an order like that. Within a few weeks of the judgment, the Ukrainian Minister of Justice, Oleksandr Lavrinovich, was quoted in the media saying that he doubted the judgment could be fully implemented. And so it seems we face another fight on our hands on that one in the coming months. But these developments do represent a ratcheting up of the court's powers, but in a way which is measured, I think, and which has been necessitated by states' non-compliance. There is no doubt that they are viewed as a threat by some governments and some politicians. Read the Hansard debates here about the prisoner voting rights issue. Politicians from each of the main parties have collectively dug their heels in response to being told by judges, and foreign judges too, that the law must be changed. I was discussing the Volkov decision recently with a former government agent who deals with Strasbourg cases, and his immediate response was to suggest that it was a disastrous precedent. I simply don't agree with that. But let me turn again back to the gross and systematic violations, the like of which we've been seeing in Chechnya. In regions of conflict, the court has played a very important role in casting a spotlight on the nature and extent of human rights violations, often in the absence of effective prevention or monitoring work by other regional or international human rights mechanisms. There are nevertheless real limitations in the court's oversight, and I want to try to explain why that is. It's important to acknowledge, first of all, that there has been a remarkably high rate of findings of violations of the right to life in the Chechen cases. In other words, that the Russian government, Russian state agents are found to be directly responsible for the deaths. There are now more than 200 European court judgments finding violations perpetrated by the Russian security forces in the North Caucasus region. And that's not only in Chechnya, but also in Ingushetia to the west and Dagestan to the east in particular, amongst the other republics in the North Caucasus. And here I've got some numbers for you. These numbers, in fact, are slightly out of date, so if you can imagine the bars are a little bit higher than they are. The column on the far left shows the number of cases in which the Russian state has been actually found responsible for causing death. So on this chart it's 167, it's a little bit more than that now. And the next column shows the number of cases in which there's been a separate violation of the right to life because of the failure of the state to carry out an effective investigation into a fatal incident. State responsibility has been established in a very high proportion of the Chechen cases, despite all the evidential difficulties. Take the profile of a typical disappearance case in the North Caucasus, which is this. A group of 15 to 20 men turn up at a house in the early hours of the morning. They're heavily armed, they wear no identifying uniform or insignia. They forcibly enter the house and they take away one or more of the members of the family. They don't explain who they are, why they're taking the person away, or to where. And then a few hours later, the family starts the rounds of visiting all the local state agencies to try to find their relatives, all of whom deny any knowledge. The relative is never seen alive again. Sometimes a body is found. In that sort of situation, would a neighbour see anything, and if they did, would they feel able to offer to give evidence? And the burden of proof, remember, is on the family to prove their case at the European Court beyond reasonable doubt. But as I said, in spite of these difficulties, you can imagine state responsibility is in fact being established, and that in itself is highly significant. But there is a but. In many of the disappearance cases, the court's processes have not enabled the victim's relatives to find out whether in fact the victim has died, rather than being presumed dead, or how, when, or where they died, or which state agency or agents were responsible. These are, of course, the most fundamental questions which a family asks, and they're not being answered. This is an unacceptable lacuna and one that needs to be tackled. One way to do so would be to acknowledge in this particular context the right to know the truth as an integral part of reparations. And this is an area where the European Court could justifiably draw on the inter-American jurisprudence. The Inter-American Commission of Human Rights, for example, has affirmed the right to know the full, complete and public truth about the events, their specific circumstances and who participated in them. In cases such as disappearances, the Inter-American Court has reiterated both the specific right to know what happened and the right to know which state agents were responsible. The extent of the right to know the truth was formulated in this way in the Cotton Field case in the Inter-American system, which concerned wide-scale systemic gender-based violence against women in Mexico. In Europe, will we follow the Inter-American lead? In 2011, in a case concerning the anti-government demonstrations in Bucharest in 1989, at the time of the overthrow of the Ceausescu regime, the European Court acknowledged the importance of the right of the victims and of their families and dependents to find out the truth about the circumstances of events which involve large-scale violations of rights as fundamental as the right to life. There are also recent signs of further movement by the European Court on the question of the need for an effective investigation into human rights abuses. The culmination to date of the cases from Chechnya was a decision at the end of last year in the Abdulkadyrova case against Russia. There, the European Court for the first time recognised that there has been a systemic dysfunction in the investigation of disappearance cases since 1999. And it went on to call on the Russian authorities to account for the circumstances of those deaths and the locations of the graves, and to establish a single high-level body to solve the cases, and to carry out large-scale forensic work, to give relatives access to the case files, and to provide compensation. Although most situations in which reparations are given for historical injustices tend to be the result of political rather than legal processes, an important indicator of the European Court's stance will be the Janowiec case, which is currently pending before the Grand Chamber of the European Court and concerns the murder of nearly 22,000 Polish prisoners of war by the Soviet Red Army in April and May 1940 on the instructions of Stalin and Beria, often known as the Katyn massacre. And the case in Strasbourg highlights the tension between the non-retroactivity of international treaty obligations and the extent to which there may be an ongoing duty to carry out an effective investigation into an event which occurred before a state ratified the treaty. Janowiec is a case in which Iraq has intervened in the European Court litigation as a third party with Memorial and the Transitional Justice Network at Essex University. And in our submissions that were drafted by Joe Evans and Jess Gavron, we've argued that the duty to investigate and account for international crimes and gross violations of human rights exists even if prosecutions are no longer possible. We also say that this duty is owed not only to the victims and their relatives, but also to the society in which the violations took place and to the wider international community. The rationale for this is the importance of creating a historical record, of ensuring accountability and eradicating impunity, promoting reconciliation, as well as respecting individual human dignity. I want to turn finally to the question of what happens after these judgments are issued. We've heard that damages get paid, but what other changes in laws or practice should follow, and who monitors what happens or indeed what doesn't happen? In the European system, it's a political body, the Committee of Ministers, whose role it is to ensure that judgments are implemented. An absolutely pivotal function, but one which too often fails in the difficult cases. In effect, you have senior representatives of the states that are in the dock in Strasbourg who are deciding on follow-up. The system is based on peer pressure and depends on the willingness of European states to exert concerted pressure, especially in the face of persistent recalcitrance. The current hostility towards the convention system emanating from some British political leaders, it seems to me, will only serve to further undermine the weaknesses in these processes. And there is a real risk that victims of human rights violations in Europe will suffer for longer, and they may be denied justice and redress. I don't believe it's the European Court failing its mandate that is the problem, as some commentators in the UK would have us believe, but rather that European states are unwilling to fulfil their responsibilities to act collectively and effectively to enforce the Convention. Take the case of Chechnya. What of the follow-up to these appalling human rights violations in Chechnya, some of which you've heard of this evening? What's the response of other Council of Europe governments, including the UK, to disappearances and extrajudicial executions repeatedly being perpetrated by one of its members? These cases have come before the Committee of Ministers since 2005, but very little progress has been made in ensuring that such cases are now the subject of effective investigations. In the last 2 years, Iraq and Memorial have been pushing for the use of a new European intergovernmental mechanism, infringement proceedings, to highlight this particular situation. However, as yet, no state seems to have the guts to challenge Russia over Chechnya. And mirroring the situation in Turkey that I mentioned earlier, the application of statutes of limitation in Russia of 10 or 15 years may also soon mean that prosecutions become time-barred in Russia, so we do need to act. When we contemplate the adequacy of the court's position on redress, it shouldn't be forgotten that the role of an international court is to rule on human rights violations which have been committed by the state as opposed to private individuals. And we should also remember that human rights violations are not just committed against individuals, but also represent breaches of the wider social order. In this broader context, the provision of redress also serves the additional and vital function of upholding the public interest and the rule of law. The court is doing its job, but governments are not, and the system needs to be reformed. The declaration agreed by Council of Europe governments in Brighton last year provides a clear mandate to strengthen the system to ensure that European court judgments are fully and swiftly implemented. In the final analysis, it is a human rights court, providing us all with a safety net when national systems fail us. We owe it to the victims of state violence and of domestic violence, to the victims of human trafficking and those subjected to extraordinary rendition, to people languishing in inhuman prisons, and many others, to ensure that we maintain a strong and independent human rights court for the whole of Europe. That's it from me, and now the main event, a drink, and join us for a drink and some food. Thank you very much indeed.